You've got the client who prefers email over phone, or they're sensitive about a billing detail, or they've had a bad experience they don't want revisited. One person on your team knows this cold. Then that person's on vacation. A substitute takes a call, and suddenly you've violated the preference and you've lost the client or the case. I'm Daisy Lopez, a growth specialist here at Legal Staff Now. We've placed and overseen vetted virtual legal staff at more than 500 law firms. We're an Inc. 5,000 fastest growing company, and our work's been featured on Bloomberg Law. We staff and oversee legal teams inside law firms every day, and we watch this happen. Preferences locked in one person's head, never documented, never shared. Firms without a system for documenting and sharing client preferences, separate from case notes, have a 3 times higher rate of client service complaints and case attrition than firms with a client profile system. Your lawyers know how to practice law. The gap is the system. No place to document what matters to the client, no way to pull it up when your regular person is out, no protocol to share it across the team. Think about it. Your clients prefer email, no phone calls. It's a known thing. Then Monday, your paralegal's at a conference and a substitute dials a client cold. Or the client mentioned once, years ago, a topic that caused them real pain. The new team member doesn't know. You circle back to it in an intake call, the client's furious. Or you send an invoice for a cost your client told you last year they wanted to approve first. No documentation of that conversation. They think you violated the fee agreement. The State Bar of Arizona puts it plainly. Their exact words: failures of diligence and communication are the most common complaints about lawyers, not malpractice, complaints. The bar is hearing about this constantly. The pattern is clear. One person knows it all. Then they leave the firm, or they take time off, or they go on parental leave, and the knowledge walks with them. The client relationship dies, not because your lawyers are incompetent, but because the system didn't protect what the client told you they needed. So here's the move. You need a dedicated client profile system, separate from your case notes. This is where you log what the client actually needs from you, how they prefer to hear from you, what topics are off limits, what billing practices they've told you matter. Step 1, ask in your intake process. How do you prefer to hear from us? Email, phone, or a mix? How often? Write it down, put it in the profile, not the case file. Step 2, ask the client explicitly. Are there topics or past experiences with attorneys that are sensitive? Anything we should know to serve you better? Get it documented. Step 3, in the same intake call, clarify billing. What costs do you want to pre-approve? What's our protocol if something unexpected comes up? Get it in writing and add it to the profile. Now here's the key. Make the profile searchable and accessible to every team member. When anyone on your team touches that client file, they can pull up the profile in seconds. No guessing, no tribal knowledge. When your regular paralegal goes on vacation and a substitute steps in, the substitute should know the preference before they touch the file. In your weekly client management or case status check-in, glance at the profile. If something's changed, the client's preference, a billing concern, flag it. Keep it current. And look, this isn't extra overhead. This is the actual work of keeping a client happy and protected. You're already doing the intake conversation. Now you're just documenting it in the right place. Clio's 2025 Legal Trends Report documents that client communication preferences are shifting, a mix of traditional and digital channels. Your clients aren't all the same. They don't all want email, and you have to know that. Here are the stakes. A preference breach isn't just a complaint. It's negligence. The client can argue you violated ER 1.4, that you failed to keep them informed in the way that they asked, or that you ignored a billing boundary that they set. When the complaint lands and your malpractice carrier investigates, they will ask, was the preference documented? If not, you've got no defense. You're exposed. Documentation is your only protection. It proves you listened, you acted in good faith, and you followed the client's wishes. The good news? You build the system once and it runs. Your intake process captures it, your team uses it, and it pays for itself in the first prevented complaint. Don't lose a client or face a bar complaint because a preference was locked in one person's head. You have the chance to fix it now. The move is simple: document client preferences, make them accessible to your whole team, and review them regularly. It's the safest, smartest way to keep clients happy and to keep your firm out of a bar complaint. If you're ready to move client preferences out of one person's head and into a system your whole team can access, book a call with us. We'll walk you through how to set it up and what to capture during the intake.